Good evening, everyone. I welcome you all to the webinar on today's webinar. I have learned over the years that when one mind is made up, this diminishes fears, knowing what must be done, and that does away with fear. Do the thing you fear to do and keep on doing. This is the quickest and surest way ever yet discovered to conquer fear. We are all here being fearless, learning and taking the most of this session. With this, I would like to welcome all our guests of honor, panelists, and participants in today's webinar. Before we start technical session, I would like to take a moment to introduce JIPA Professional Association. JIPA is a platform where professionals come together and share their knowledge and give insights. We here at JIPA also hold professional networking events. We have a vast resource database useful for professionals as well as job seekers. JIPA has a panel of active expert professionals, and I am proud to say JIPA is also involved in CSR and welfare activities. And I said this is a good opportunity to take advantage of this platform and become a member of JIPA. Now I would like to introduce Association of Financial Advisors of India. The Association of Financial Advisors of India is promoted by eminent financial experts and industry leaders of India who have joined hands together to establish a platform for exchange of knowledge and experience for the benefit and betterment of all its stakeholders. This strong intelligentsia group constituted from diverse segments of the financial professional with pledge to standardize the service delivery mechanism to rebuild the funding and enterprise architecture so as to bring in discipline and ethical practice of all the stakeholders of the industry, namely the entrepreneurs, lenders, borrowers, regulators, policymakers, and the government of respective states and center. Now I would like to welcome Vice Chairman of Committee of IBC JIPA, Manoj Anand. He is a professional insolvency professional and chartered accountant, founder, president of AIIPA, and co-convener of IBC Group. He co-authored book on valuation. He is visiting faculty of various seminars held by ICI, ICSI, CBI, and regulatory and other write articles on IBC and income tax. Going forward, I would like to introduce the person behind JIPA, founder CA Praveen Kumar Jain. Praveen sir is BCom Design Insolvency Professional, qualified independent director, registered valuer. I must take a moment and congratulate Mr. CA Praveen sir for his dream of JIPA Association and tirelessly working day and night to make it success and helping all of us to gain valuable insight in different topics. Now I would like to request Praveen sir to please come for the welcome address and honoring our guest of honors.
Thank you, Pallavi. I welcome to our chief guest, Mr. Mukul Saha, DGM, Sam, Punjab National Bank, C&IP Rahul Jain, President, Association of Insolvency Professionals, Nipun Singhvi, Advocate and CA, CM&IP Ashok Kumar Gupta ji, Managing Partner, Pro Resolution Advisor, LLP, Mr. Sunil Gupta, Vice President, Resolution Professional, LLP, and Advocate Piyush Jain, Director JIPA, C&IP Ritu Rastogi, Vice Chairperson JIPA, IP RK Goyal, Chairperson IBC Committee JIPA, and our moderator, Mr. KK Gupta, Director, Association of Financial Advisors of India. With this, I want to share that topic for this today webinar is recovery and resolution. Recovery for bank and resolution for IBC. Both are contradictory and we should resolve this. And with this, I also want to introduce our Vice Chairperson, CA Ritu Rastogi ji. Some highlight of this, we welcome and congratulate to CA and IP Ritu Rastogi in our JIPA family on joining JIPA Professional Association as Vice Chairperson of the association. Brief introduction, she has started her professional career from our firm known as Master A.K. Garan Associate Chartered Accountants in the year 1991 and associated with us since more than 30 years. She is commerce graduate, CS, CS Inter, and insolvency professional, having more than 25 years experience in the area of financing, restructuring, settlement, revival, rehabilitation of sick companies, acquisition of debt through asset reconstruction companies, and a part of core management team involved in the strategic decision making for turnaround and business financial restructuring. She is a result-oriented professional providing strong proactive leadership to the team of financial and immigration professionals. She has attained a great height both at professional and social level. She has varied and vast experience in the area of financial insolvency and bankruptcy law. She has completed a number of cases as insolvency professional, resolution professional, and liquidator, and having panel with various banks. She has multi-dimensional personality and having much more capability than that executing at present. She is like a sunlight to a professional committee and to be called as the pole star. She has set up professional company known as Swastik Professional Services Private Limited, and a number of cases have been settled through assignment of debts to asset reconstruction companies. Besides, above she have adequate exposure to finalization of accounts, statutory audit, tax audit, budgeting, MIS, and due diligence. She has also worked with Dheer and Dheer Associates, Roll Tenors Limited, Hindustan Fiber Limited, and Lodha and Company chartered accountants in her professional career. With this, I also introduce Mukul Saiji, DGM SAM, New Delhi. He joined EOBC in 1993 as provisionary officer and worked in operations, credit, recovery in different places, Gujarat, MP, Haryana, Delhi, Punjab, etc. Lastly, he handled the recovery and resolution vertical of Amritsar zone of PNB, and at present looking after the same portfolio of Delhi zone. He has now promoted as General Manager GM at Delhi zone. We heartfully congratulate at his promotion after a successful long journey and wish for his bright career to take height at top levels. With this, I request to Mukul Sahi, please address to the session for a meaningful presentation. Mukul Sahi, please, sir. Please unmute, sir. Yes, sir.
Am I audible?
Yes, sir. Yes, sir.
Yeah. Thank you, Jan sir. Thank you, respected distinguished guest of this evening. First of all, I thank you very much for giving me opportunity to interact with you. And I know this is going to be a very wonderful evening because so many eminent personalities are sitting here. I have gone through their biodata, and I'm quite sure that I'll be getting much out of today's this webinar. So starting with me, just I want to throw some light on prudential norms. So in line with the international practices and as per the recommendations made by the Committee on the Financial System, the Reserve Bank of India, as we all know, introduced in phased manner prudential norms for income recognition, asset classification, and provisioning for the advanced portfolio of the bank, so as to move towards greater consistency and transparency in the published accounts. So, in fact, the policy of income recognition is based on the objective, and primarily it's based on record of recovery rather than on any subjective consideration. Likewise, the classification of assets of banks has to be done on the basis of objective criteria, which would ensure a uniform and consistent applications of norms. But if you go by this insolvency and bankruptcy code 2006, just I want to, everybody is well aware of this difference between both the things. But so far as banker's perspective, as I told that this income recognition and this is based on the objectively based on the record of recovery. And here the recovery is the main thing which we look for to reduce the level of NP of the bank. But so far as IBC 2060 is concerned, from the banker's perspective, it's paradigm shift from the prevailing legal framework, putting the financial creditors in the driver's seat and empowering them to take crucial decisions regarding resolution, which are binding on all stakeholders, including government agencies. Here in insolvency, under IBC code, we have the liberty to not only effect recovery, but also to see whether a unit which is sick or which needs to be rehabilitated, are things are in proper place, or are we doing adequate, or are we taking adequate steps under IBC framework to make a particular unit viable. So here we find the opportunity to make a unit viable or make a unit going concern, apart from keeping an eye on recovery prospect also. So today I'll not share much with you because so many eminent persons are already sitting here, and I would like to hear much from them and to gain experience from their thoughts. So this is all from me, and I hope that, as I told, I would like to hear much from eminent just sitting here. So from the banker perspective, as I shared with you, IBC 2016 as of now is really going to is very useful tool for bankers. And so far as Punjab National Bank is concerned, we have number of big accounts, and with the help of this dispensation, we have solved or we have recovered good number of accounts, and not only good amount of recovery has been effected. Besides this, we have also been able to keep the nature of number of accounts as a going concern, and just the other things which are associated with these issues, like if concerned, if a unit becomes a going concern, employment is there, it will contribute into national economy. So these things have been addressed while we are dealing the case under IBC 2016. So this is all for me. Thank you very much.
Thank you so much, sir. And now moving forward, we will be proceeding towards the technical session. Before starting of technical session, I would like to introduce you to the KK sir. He will be moderating the technical session, and then I will be introducing you to the panelists, today's panelist. Mr. Krishna Kumar Gupta, Director of Association of Financial Advisors of India. Being director of a company, the main responsibility is to cater to the director needs of the SME sectors and big industries. Mr. Gupta is also task force manager of MOU, constituted by Government of India, nominated as a member of a grievance committee of Power Finance Corporation, and consultant ruling banking law Panchayat National newspaper. We are blessed to have you here, sir. Now, our first panelist of the day is Mr. Nipun Singhvi. He is a practicing advocate. He is FCA, CS, LLB, LLM, certified forensic IFRS bank auditors, qualified independent director. He is also financial, social, and RTI activist. He is part of various committee of ICI on corporate laws, bank audit, accounting standard. He is contributor to the WIRC reference manual on insolvency laws, Guide to IBC by Bloomberry, Taxman Gujarat RERA manual. He has delivered more than 1,500 lectures on various laws across 50 cities. He is regular faculty to ICAI, ICSI, Nationalized Bank, CAG, and Trade Association. Welcome, sir. Next panelist of the day is Ashok Kumar Gupta. He is insolvency professional, management auditor, virtual CFO, and business consultant and advisor.
Just a minute, Rahul ji is there. and you should introduce first Rahul, right? Guest of honor or guest of honor.
It's okay, sir. Please carry on. Introduction can be done at the last. Please carry on, ma'am. No issues. That's fine.
Very nice, very nice.
That's not an issue.
Carry on, madam.
Just
Carry
introduce
on,
and
please carry on.
call him for their deliberation, please.
मैं इंट्रोड्यूस करवा दूंगा कोई प्रॉब्लम नहीं है चलने दीजिए आगे
Now then I will introduce him. Rahul Jain is our guest of honor, and he is IP RBSFA BCom honors, and he is a fellow member of ICI and CFA level 3 candidate with over 16 years of experience in financial reporting, transaction advisory, valuation, etc. Rahul had qualified CA in May 2005 in first attempt and started his career with PwC, a leading global auditing firm, where he had worked for 4 years and performed the audit of several blue-chip listed companies, primarily in the telecom and manufacturing sector. He had also worked with Fidelity India, and he practiced since July 2011, leading the firm as a Rahul Jain Company CA. The firm is based in Delhi and is involved in area of audit and taxation, including statutory and tax audit of various companies and firms across various sectors. Rahul is well versed with modern accounting system, financial management. Rahul is a registered evaluator since May 2020 and is an insolvency professional since October 2020, registered with RBI. Rahul is very proficient in financial modeling and restructuring and have deep knowledge of corporate finance. He has performed valuation engagements, including intangible asset valuation, purchase price allocation, option valuation, determining share ratio for merger, review of business models under acquisition, etc. as an insolvency professional. He has several engagements, primarily leading to infrastructure. He is also president of Insolvency Professional Association of India. With this, I welcome and invite Rahul to deliberate their sessions, views, and share your views. Please, sir.
Thank you very much, Praveen ji. Thank you very much for giving me this opportunity. And on behalf of my association, I thank JIPA for inviting me to this esteemed platform. So JIPA is always actively involved in organizing such knowledge programs. And this time also it's a very good topic because see, in the last 2 decades, the government and the RBI has shifted from the recovery mindset to the resolution mindset. Because I mean, eminent speakers are there, they will be covering the topic in detail. But to have a holistic view, what I mean perceive from this is that banks are there in an economy because banks are required by a country for creating credit so that economic activities can be boosted in the country. So when a business gets shut down, the employment gets destroyed, the production of goods and services gets destroyed. So it has an impact on GDP, it has an impact on consumption as well. So neither the government nor the RBI wants to have a negative impact on the economy. But at the same time, they have a challenge of NPAs. So, but from the recovery mindset, when SARFAESI was introduced, then BLRC comes up with this resolution mindset that there should be recovery of amount as well, and the business should not be shut down. There should be a chance to revive the company even at the liquidation stage where we try to sell the company as a going concern. So business is very important, and the RBI and the government is understanding these things, and we can see in our current policies much emphasis is laid on the resolution rather than recovery. So all these things will be covered by our eminent speakers in detail, I am sure. So with these few words, I thank you again for inviting me, and I hand over the dais back to you. I am truly humbled to share that stage with so many eminent dignitaries. Thank you for inviting me, sir. Thank you very much.
Thank you, Rahulji, thank you. And Pallavi, please continue there.
Thank you so much. Thank you for your kind word of wisdom. Now continuing with the profile of the panelists. Our second panelist is Ashok Kumar Gupta. He is insolvency professional management auditor, virtual FCFO, and business consultant and advisor in international business. Chairman of Delhi chapter of RIPA, managing partner of Pro Resolution Advisor, member of Research Committee of Valuation of IOB, ex-advisory member of IPA of ICI, treasurer of II Images, and faculty of Valuation Insolvency, and also doing advocacy for RBM, resolution by mediation. Welcome, sir. Last and not the least, we have a third panelist, Sunil Gupta, in our panel. Sunil Gupta, he is a Vice President of Resolution Professional LLP, cost accountant by profession, and PGDMBM, having more than 37 years of post-qualification experience. He is presently heading the IBC division of Resident. Mr. Gupta is overseeing over 15 live assignments and have been instrumental in successful closure of 5 assignments during the past 2 years of his association with the researchant. A keen planner, strategic, and having successfully handled a gamut of finance and account space with strong inclination towards the system approach. Now I would like to hand over, welcome sir. Welcome Sunil Gupta sir. Now I would like to hand over the session to Krishan Kumar Gupta for moderating the technical session. So you can take forward from here.
Thank you, madam. Thank you very much, Pallavi madam, for giving a great introduction to all the eminent speakers. At the outset, I express our gratitude to Mr. Parveen Jain, who is the chairman of JIPA Professional Associations. I think this is the first of our joint venture program with the Resurgent Professional LLP, Insolvency Firm, Resurgent India, and Association of Financial Advisors of India, which was constituted, and Mr. Madam has explained the object of our associations. The today topic is very, very important topic. We will talk about the RBI Prudential framework for resolution of stress assets and management of the stress assets under IBC code. I will not say act because it is a code. So just I want to tell you, for the Indian economy, for the national desires, that we should have a 5 trillion economy within remaining 2-3 years period. And to achieve that economy, most important aspect is economic liberalizations, which was introduced in 1991, which is continuing. Even the present government has come out with so many schemes. Either you talk about the zero defect, zero effect, either you talk about the Make in India, and having committed even once a times to India was borrowing, even getting donations. Now position has entirely undergone change. Now about 30.6 billion US dollar kept as for donation to the Asian neighboring countries and also to the Africa. This is one aspect of the economic liberalizations. Then I'm talking about the second aspect of the competitions. Competition Commission of India was constituted. The main object was that to promote and sustain competition, protect interest of the consumer, and ensure freedom of a trade in market of India. These two aspects were there. Lekin foreign investment was not coming because we have no some exist route. With the introductions of IBC, when we're talking about IBC, Insolvency and Bankruptcy Code, which was introduced on 28th May 2016, enacted Insolvency and Bankruptcy Code 2016 to seek to tackle the non-performing assets and consolidate the existing framework by creating a single law for insolvency and bankruptcy. After this, what happened when we're talking about 2016? Now we are talking about 2022. So we feel that about 7.56 trillion cases up to December 21 claim was filed. As for figure available with us, it was 2.5 trillion recovery was constituted, which you can say about 36% or 34% recovery was made available to that. Decide under the stress assets of the circular of this 7th June 2019, so many recovery restructuring were taking place. I am very happy that Mr. Rahul Jain touched very important aspect. You're talking about recovery to resolutions. I think this is the most important issue, Mr. Rahul, which you have touched about. And you also touched about the economic activities. And most important aspect, which you have touched, is a going concern. Because the object is not to have a liquidations. Liquidation is not a subject for that. Whether going concern, how IP can be helpful to a going concern. So we are with us, so many people with us. We are going to discuss how the concern can be going concern and what are the challenges are being faced by the IP. Whether you talk about the availability of the funds to run the units and expertise under the fields and so many other issues are also there that we were going to discuss with that. Important aspect is the NPA level, which Rahul also touched. Now we are talking about NPAs, which was about 7.5% of the gross NPAs as on March 21, which reduced to 6.9% as on September 2001. Now it is envisaged, it is anticipated that it may go up to 8.1%. So why this NPA is going up? In spite of having a restructuring, automatic emergency line of credit, the bank has provided. These are the aspects which we are going to discuss in details. I will not take much time because already half an hour had gone. So only 1 hour left with us. If we are going to speak, I can speak 1 hour for these aspects. Lekin I want to listen to the other speakers, other eminent person. When I have seen the biodatas of the profile of the people, I was really amazing how much learned people are with us today. So we'll definitely will get something from them. I'm coming to, I think, Mr. Sahai, who is, I must congratulate him for his promotion as a general manager of the bank. And he's looking after the SAM, which is an important portfolio of the banking sector. I will not touch much about him. Because I'm just talking about he also talked about the Prudential and IBC. When we are talking about the Prudential norms, Prudential framework, we are talking about the debtor taking a lead. And it is certain happened under the Prudential framework, their management undergoes change. Because when we are talking about the insolvency and bankruptcy code, which we feel that liability side, either you talk about the financial creditors or talk about the operational creditors, they are taking a lead. Even the corporate are going to the NCLT for the resolutions. So there is, when default happened, then people go to the NCTL. So my point is the control best with the IP. IP play a very important role when admission is there. So my only point is from Mr. Sahai, because he is helm of the SM, which is the backbone of the Punjab National Bank for having the recovery, for having the resolutions. So just I want to know from him, what is his personal experience for that? And how you feel that whether IBC is good beneficials or a Prudential framework of RBI, which is on 7th June 2019 is beneficial. So I hand over to Mr. Sahib for his view. Sahib, sir.
Yes, thank you. Thank you, sir. So far as IBC 2016 is concerned, it has, as it was brought to our notice, or but as told by the previous speaker, it has separate role, a distinct role. It looks into recovery and also with an eye on resolution of the account. First, to ensure that a unit, if it has the potential to be a going concern, it should be given support so that it can be a going concern and thus should survive. So, with keeping this point in mind, IBC 2016 is definitely a good legal framework to address the issue of NPA with a broader mindset, with the keeping in mind the employment aspect, contributing to the growth of the nation, contributing to the economy. So, and so far as Prudential framework is concerned, as I told in my opening remarks, that it is objective and based on the record of recovery. Here we have the sole aim of recovering NPA locked over years by way of SARFAESI, by way of DRT, Lok Adalat, various means. So here our main aim is to recover the bank dues from borrowers by way of this dispensation available to us. But here in IBC 2060, we have a different view that, as I told, that apart from recovery, our aim is also to see that if we can contribute, we can help in the entire process to make the unit, to keep the unit as a going concern. So, keeping in this in mind, wherever we find opportunity to move, to look into the fact that this can be resolved through IBC 2060. So we take the issue into that direction and try to solve the issue, try to resolve the account. And in this pursuit, I think IBC is also a very good tool with bankers. But there are certain issues involved here which are well known to us. Cases are not admitted for long period. Number of issues are pending. We have not been able to reach to the point from where we see a vision to recover the bank account or otherwise contribute in making the unit as a going concern. So there are a number of issues involved there. So that needs to be addressed. Again, timeline of 330 days are also there. There are a number of issues where cases have yet not been resolved. So these things are of course there, but still recoveries are coming with this IBC 2000 with the help of this framework, and it has its own beauty. It has its own issues. And in day-to-day, we all are agree that in day-to-day there are a number of changes coming out, and we are quite hopeful that with the changes and with the progressive mindset, I mean certain sorting out of the issue, it means resolution of bad debt through this mechanism will also gain momentum, apart from the traditional recourse which bankers have available, with which we call as Prudential norm. So my mind it's a good, IBC 2016 is a very good measure. And we have been able to recover substantial amount out of this framework, but still some changes, progressive changes are required to be made. And our eminent guests and speakers who are available here, and I think I request them to address this issue by way of their innovative ideas, which ultimately will going to benefit us also, because in day-to-day life, banking life, we are confronting a lot of problems, lot of issues, and ultimately we have to reach to you people to sort out the things. And just day before yesterday, I was talking to Jan Saab. We had number of issues where we are at our wits and we do not know where to go, and ultimately we are bound to come to you people. So, but still, I say that this thing, IBC and Prudential, and not only IBC, apart from IBC, this Prudential norms which are available to us are really helping bank, and we are making benefit out of this, and ultimately this is going to help bank in the days to come. We are not the path of progress because we are locked. Large number of NPAs are with. If I talk about Punjab National Bank, we have large number 2 lakh crores of NPA with us, and we are desperately moving the direction to reduce this level of huge level of NPA with the help of these guidelines. And at this juncture, we require the support and help and insight of all eminent persons associated with our bank. So how new measures should be adopted and how things should be taken at face value to address the issue of rising NPA. So
very nicely, sir, you have rightly touched about the ongoing concern and other things aspect. Like one point, simple, just I'm asking as a banker, because this Prudential framework also mentioned about the special mention account, whether you are 30 days or you can say 60 days, and talking about the 90 days. And if it is a default occur, they are asking for 30 days, you have to review the accounts. So what are your views, sir, for that? For 30 days, review the account, and what type of review are being done to avoid to slippage to NPAs or to have a recovery of the default? Have any views, sir, on that subject?
Yes. In fact, SMA 0, SMA 1, SMA 2, we get details of all such accounts on very periodic basis, and we try to address the issue based upon the nature of issues. Like if a stock statement is not there, matter be taken with borrowers to receive the this stock statement if interest is not paid. So such type of different type of issues due to which account turns into SMA are being addressed by bank at different level, at branch level, at mid corporate center level, at zonal office level. So based upon the nature of ailment, we address the issue from different levels. Be it a stock statement, I told, non-submission of a stock statement, non-deposit of interest, and non-submission of balance sheet, non-renewal of account. So far as Punjab National Bank is concerned, this SMA reduction is, as on date, is very much on a priority level, and we try to nip the issue in the bud. Means rising NPA, if we take care of the account at SMA level itself, then it will not translate or it will not slip into NPA. So of course, containing SMA at initial level by addressing the issue of addressing different sort of issue is on top priority, and it is being taken care of at all level with utter sincerity.
Thank you, sir. I think you rightly touched about the special mention account. Now I'm coming to CA, Mr. Singhvi, sir. He is advocate also. When I'm seeing his biodata, he is a member of World Bank Insolvency Group on train and trainers. He also delivered more than 1,500 lecture on various laws and across 50 cities. Handle insolvency cases of 1 lakh crore rupees, including JP Infotech, Lanco Infra, SR Steel, SR Oil, Shipping, and so many PIL, public litigation, interest litigation was filed by him. So just I want to know, sir, so what is your experience for the home buyer? Because these are the burning topic and so many participants under this webinar, we also interested to know why the buyer, how, what is your experience for the Infotech, or you can say SR Steel, SR Oil, and what are the, my point is whether for any, another question, what I am asking you, for any liquidations, whether any economic value are being considered while considering the liquidation aspects. There are two questions. One is, what is your experience for dealing with the home buyer? Another question is, for liquidations, what is the economic value, whether you are considering for that? I hand over to Mr. Sangvi sir. Sangvi sir.
Thank you very much, Gupta ji, and thank you, Praveen ji and Jeepa, for calling me again and again. Sir, your question is very pertinent, and I must tell you very honestly and very frankly that I have been working in both the fields of RERA and IBC right from the time when the Act was also not there. In fact, when IBC was only a bill, and the first time Mr. Vishwanathan tabled it, it was a question of huge debate in the parliament, and therefore joint parliamentary committee was made. And I am happy to share that I had assisted the joint parliamentary committee at that point of time. So at that point of time, I must say that we were never thinking that this will become law in such a short span. I am talking about 2015. And in 2016, when NCLT was notified, because 2013 to 16, Companies Act came out with NCLT concept. And even in these 3 years, we were going for BIFR and IFR. And as you are aware that BIFR and IFR were only in Delhi. So it was very difficult and painful for everybody across India to approach Delhi and get their matter registered. Just to get a registration, I remember we used to take 3 to 6 months, depending upon the matter. At that point of time, we never thought that IBC will turn out the tables like this. And interestingly, sir, in 2017, I tell you my personal experience, my matter was transferred because that BIFR got closed. All the matters pending in the BIFR got transferred to NCLT. Now, when we used to go to NCLT, sir, there was no courtroom as such. There was no court just sitting in the courtroom. When you used to go, they used to call us in the chamber. And I used to go into the chamber of the judge and explain him that, sir, this is the new law. You have to do it like this. They say, okay, Mr. Singhvi, you only guide us how to do it. Because this is new law. I don't know how to do it. At that point of time, I remember in NCLT Ahmedabad, there was one Mr. Babu, Vicky Babu, honorable member. Now he is retired. So he used to ask me, sir, I am basically from a civil or criminal background. And I don't know how to handle these matters. What is NPA? What is default? I don't know. Explain. So that is how it is started. And in somewhere in 2017 end, when, though a disclaimer, I was also an advocate in the SR Steel matter, November 17, we never knew before 23rd November that promoters will get disqualified. So till 23rd November, the view was that promoters will be able to buy back the SR Steel again, and there will be a huge haircut on the banker side. And I still remember the first bid of SR was around 18,000 crores. That was the first bid. And we all know it got sold in 42,000 crore. Even when at the last point of time, they were coming out with 54,000 crore, the bid. So that is how the IBC has changed the landscape. The money may be kept by the promoters in some other company or some pockets, and that has helped in resolution. In 2017, sir, as you rightly said, that in real estate company also, parallelly, this happened in JP. So I am happy to be part of both the matters which went till Supreme Court. And in the JP matter, it was so difficult to explain that the home buyers are also a creditor. If you remember at that point of time, the view taken was they were neither operational creditor nor financial creditor.
Right.
In fact, IBBI also came out with a residuary claim form of other creditors, and the home buyers were asked to file their claim in that particular form. And there were conflicting judgments. Some judgment of NCLT Delhi said that they would be a financial creditor. Another bench said that they would be operational creditor. Then they said that you have to go into the contract, read the clauses of contract, and then decide whether it is operational, financial, or other. So there was huge confusion. The problem was, I don't remember the figure now, but somewhere the financial creditors, that's the bankers, it was somewhere, I think 7,000 crores was the debt from their side to the JP Infra. But the home buyers claim was more than 21,000 crores. So the claimants who were home buyers were actually outside the room. I would say a room of COC, and in the COC there were bankers who were having much less claim. This actually matter was agitated, went to Supreme Court twice. Supreme Court also issued notices to government. Government appeared. They put their point of view. Ultimately, the conclusion was no. Because home buyer is somebody, if I am, let's say, earned 5 crores, 10 crores in my whole life, and I am buying a property, and I am not getting that property because that company is under insolvency, it is not a subject matter of whether I am a creditor or not creditor. I have put my whole hard-earned money into the company, and now I am left with nothing. And bankers will get everything. So that was the logic why government also came out with the amendment. Supreme Court also gave a verdict, and the home buyers were ultimately classified into financial creditor. But the problem continues even till today, sir. The reason is this wise, that they say that first of all, you have to be an LOT under RERA law to become a financial creditor under IBC. So first I have to become an LOT under RERA law to qualify to become a financial creditor under IBC. Now RERA law itself came parallelly with IBC. So if a company is not covered under RERA, what is the fate? So again, you have to justify, clarify, satisfy NCLT that, sir, if RERA is seen, then I will be an LOT, even though RERA is not applicable to that particular incomplete project. So that is the first challenge from the home buyer side, which I have seen. Secondly, we normally refer to word as home buyer. But sir, if we read the law, there is no word home buyer. It is the word LOT. So even if I have bought a shop in a mall, in a commercial project, I am also covered as a financial creditor. So that is very important. Initially, when the RERA law came, it was only for the purpose of residential property. But after subsequent discussion in the parliament, it also included the commercial projects. So that was something beneficial also, which helped the persons investing in real estate or consumers in real estate to come up with some relief to this particular stuck-up projects. Now, the problem today, which I am facing for many of the home buyers, and I am fighting home buyer cases in almost 3 to 4 NCLTs, issue today is we are financial creditors, but whether we are secured or unsecured. So again, that is left to the mercy of builder-buyer agreement, and which we all know in India, all the agreements are not standardized. There is no standard formula. Supreme Court has recently, I think 3 weeks back, issued directions to the government to make a standard format for all across all India builder-buyer agreement. But till date, there is no standard format. Now in builder-buyer agreement, if there is a clause, I will have to go clause by clause to say whether I am a secured or unsecured. So I'll tell you one interesting example. It will just take 2 minutes. Whether a particular home buyer in a real estate company is secured or unsecured. So let's say the value of the flat unit which I am buying is 1 crore. I have, let's say, paid 10 lakh rupees. So as per RERA law, if I pay 10% of the money, I become an LOT. So there is no dispute. I am a financial creditor. But the dispute comes whether I am secured or unsecured. So if I have paid 50 lakh rupees or if I have paid 90 lakh rupees, what should be my status? Though there is no sale deed. For 1 crore, I pay 90 lakhs. No sale deed. So if I am classified as unsecured financial creditor, probably under section 53, I may not get anything. So that is the plight of the home buyers today. My personal view and some of the matters experiences that suppose I have paid 90 lakh rupees for a 1 crore flat, it is better to give an undertaking to NCLT that I am going to pay 10 lakhs. Please get the sale deed registered in my favor. But if I have only paid 10 lakh rupees to fight for that 10 lakh and get a risk of 90 lakh that I will pay, and if the project does not get completed, is according to me not a wise decision. But if it is a 50-50 case, I have paid 50 lakhs and 50 lakhs is outstanding, then you will have to take a call whether this project can be completed. If yes, we think that yes, this is a viable project, it can get completed by the resolution applicant, definitely you can vote in favor. Otherwise, don't put another 50 lakhs on stake, because your 50 lakhs may become zero, or you may get a property, because that reasoning might differ from case to case. So this is all from my side, sir, with regard to home buyers. So it's a very different and difficult topic.
One important aspect, because you have dealt with so many big accounts, some interim finance, so you are facing some problem for that to run that unit. It is your going concern. You talk about the SR Steel or SR Power or something like that. So you are not face any difficulty to arrange the interim finance for that?
Though I have already appeared on the legal side, but from the understanding of the accounts, I can tell you in SR Steel case, it is now become a case study in IIM Ahmedabad.
Oh,
they earned, sir, 3,000 crore of profit during the CIRP. So there was no dearth of stress. They employed best people from the steel industry globally to run the company. So that is an achievement which I can tell you in SR Steel case. And that 3,000 crore rupees was a recovery for the COC members. That was also challenged by the resolution applicant saying that since I have bought it, it should belong to me. But again, Supreme Court rejected it. So they actually got some cherry on the cake also. They obviously got the recovery, and on that, top of that, they got this 3,000 crores also. So that was something good. But as far as, sir, home buyers or real estate projects is concerned, my personal experience is there is always a issue of funds, because there is a diversion or maybe a siphoning done by the builder or the developer, which ultimately is not bridged by the bankers also. I must tell you very frankly, no banks funds a project during CIRP, because in real estate project, it's a very die situation. We don't know when the project will get completed. There is a timeline. There is an issue of unsold inventory. There is an issue of home buyers who have unpaid or maybe underpaid. So that is also a very difficult situation. As of now, I don't think so that any viable option is there. But my only thing is that if RERA is enforced in true sense, money siphoning will stop, because RERA says that all the money paid by home buyer will come in the RERA designated account, and only after a CA is giving a certificate, money can be withdrawn to the extent of 70% for the project and 30% for miscellaneous expenses. So if RERA is implemented, I think the issues which we are facing as a home buyer will actually reduce.
Very nice. So important aspect, because you are there so much qualification, other thing. My point is that for the liquidations, because the people are going for maximum liquidation, the unit. So you feel that the economic value of that assets should not be considered for liquidation. What do you view in that respect? Have any view?
My view is, sir, that obviously we should always try that the company does not go into liquidation and it revives anyhow. But sometimes, sir, I have also seen the cases where the liquidation value, which today we are expecting, may increase during liquidation. Sometimes it happens in, especially in real estate cases, that the contract, which is actually in the midway, will automatically get terminated when it is under liquidation. So in that situation, the valuation goes up, because I give you an example. When you are selling a particular unit in a residential project, you are selling two things. You are selling land and you are also selling the construction. So construction is basically a service and land is basically a commodity. But in our, I would say, scenario of Indian context, we do sale deed only when the payment is paid fully. So only after sale deed, the rights in the land are created. So during CIRP, maybe some of the creditors you will have to pay them, or you will have to have more money to actually continue. But under liquidation, they will get nothing. So therefore, they will automatically put in more money. And therefore, I have seen in my practical experience, under this real estate project, liquidation, they are getting more money than CIRP resolution. So there could be some cases where liquidation may yield more money, but 90-95% cases, resolution is always better than liquidation. And therefore, enterprise value becomes very important.
Very important, sir. Very important. Resolution is better than going for liquidation. I think that Mr. Rahul also touched the same point. So, sir, I will come back to you. Now I'm coming to Shri Ashok P. Gupta, who is IP, and he is also member of Research Committee of Valuations. And he is also management auditor, virtual CFO, and business consultant and advisor in international business. Gupta sir, just I want you to know international or cross-border insolvency. How you feel that? If cross-border insolvency is also available, and what is your view? Because you are dealing with the international business.
Sir, to be frank, I would like to emphasize first thing that today's topic is very much concerned with the prudential norms of the RBI. And when we discuss about SR still, we should discuss about the cause of default.
Sir.
When cause of default were discussed by the banker at that time, I don't think SR will come into IBC.
Sir.
So interest cost would be high, any other fixed cost would be high. There are a lot of chances of the. So similarly, when we discuss about the cross-border transaction, is when the matter came to jet and the assets of the jet lying in some country. Then issue of the how to recover the money from the asset which is lying in the loss of other country, which is not controlled by us. The question about the enforceability. Second question about which mother law will governing the process. It IBC do have the right in the other international range, whether yes or no. Such things are applicable. And then whether we have any kind of treaty with that country, that is important. So when question about cross-border, first thing is come into mind, conic, where the control, where the business, and who are the affected. So that's why cross-border transaction is border insolvency is applicable when the company is having several branches in other countries or multi-companies. But again, issue is that the subsidy is not unconsiderable under IBC. If you are doing the insolvency of the holding company, the RP cannot have any kind of control over the management of the subsidiary, right? So a lot of things to be, again, this is again, IBC is a revolutionary stage. So every day we are changing. That means we are trying to achieve the efficiency and effectiveness in the getting the how to generate the economic value. And somebody is saying that we are transforming from recovery to resolution, I say no. We are transferring from recovery to generate the economic value of the asset at efficient manner. That's why time assurance is the subject matter of the IBC. So IBC is providing those things. IBC providing whatever you want to do. If you want to find a resolution within certain time limit. If you are not getting, then go for liquidation. Then liquidation is also a certain time limit. Now value increase during the insolvency. Again, a question, maybe macro variables hit in the market. Like post-corona, the surrounding area of the Noida, Gurgaon, Greater Noida hit by 30 to 40% jump. So bankers are very good in position, getting very good money in the SARFAESI. So their recovery is higher in the SARFAESI than IBC. So keeping those things, sir. So what I mean, when we have problem, we first try to ourselves to restore the problems at home. That is the prudential norms of the RBI. That lenders should sit, find the cause of default, and set what should be best manner. And then there are three remedies. One is the change in the structuring of the loan. Then with the certain provision, they can reduce and restructure the loan. Second is, if you find if promoters is not efficient, then you may invite other promoters to join the board. This is second thing. And if promoter is badmash, then you file the CBI economic forming and all the process to getting the recovery of the money. That is fraudulent transaction. So I just concluded, IBC says 32A provide you opportunity to file the case against the ex-management to recover the money of the wrong deed. In the prudential norms, there is no talking about the crime, but mention that yes, that is process which lender can take process in the other remedies. So when preventive measures start by prudential norms, first stage, second stage is called breakdown. But in breakdown, we try to again find a local mechanical person. Here, please come and see my car if he can resolve. If he cannot not able to resolve my car issue, then we will send the car to the workshop. That is called liquidation stage. So this is called third measures that is breakdown. So if we are talking about these three things, sir, we can understand where bank lackings. Now, one more thing, good thing. Earlier in the prudential norms, company was in the hand of lenders, but in the IBC, it is now in the hand of the stakeholders, not lenders. But the trade, the power control in the hand of the COC. But again, one pillar that is NCLT. Whatever, you have to convince the NCLT to get the order. So legal remedies has been shifted from this stage to second stage to third stage. And the going concern concept, in my mind, is very simple thing. If you are creating the value or economic value or employment for the employees, then I will feel that it is going concern. Otherwise, no asset is called a going concern. This is just a generating the value only. Simple. Thank you.
Very nice, Gupta. I really admire you. You are touching very important aspects. Sir, my only point is you are a faculty for valuation also. And you are a resolution by mediation. So, sir, one point as a banker, because I am also a banker, so when we are giving any loan to the party, to the borrower, that at the time valuation is too much high. When we are going for any sale, there is a distress sale and value has come reduced. So our value, what time is our value? At the time of giving the loan, we are having the valuation, or at the time of a distress sale, or you can say for filing a suit or something like that. So we are also the same value. So why is such a big gap is there available, sir? Have any views on that aspect, sir?
Yes, sir. Now you have two major issues, sir. One is about the valuation at time of sanctioning the loan, and at time of the recovery.
Sir.
They're two separate parameters. In between, there is one word is monitoring. What is the role of the bank employees when they are monitoring the loan? Whether they find any change, significant change, what are the financial indicators, what are the economic indicators which affect the industry? The industry norms, then promoters norms, what about the promoter, other group companies, whether they are doing well or not well. So many things to be checked by the bank. I just give a very good example. In 96, 97, Bank of Tokyo gave my company double the loan amount based on the performance. And after 2 years, they found some problems. They smartly reduced the limit and come out from the picture. And after 1 year, my company became NPA. So that is a process. You have to monitoring continually what is going to happen. Now valuation. What was the macro factors in 2018, sir? Prior to Corona, COVID. And what is now? Now industrial plot value is increased by 30 to 40% jump. Is it a factor? This can be also reversed. Now, as per you, at the time of sanctioning the loan, the valuation was high. And at the time of recovery, it may go down. That is made due to various issues or maybe various factors. But now I tell you one thing very good, that IBBI is doing very well work and start registration of the registered value.
Yes.
And they are going through some training and programs, and they are increasing their level of understanding the valuation. They are following the macro and micro variables. They are following the other economic indicators. They're using those concept and account and international practice valuation standard in the valuation. So now this is called, when they are improving their performance, so in the future, you should not face such time of deviation from at the time of sanctioning or this thing, except macro variables. Like share market is increasing. Now, this is reverse situation nowadays. If you see, share market is going down, gold is also going down. There is no correlation. There is no correlation this time.
Land is appreciating. Your land building is appreciating. They are not going down. And the stock market link you are talking about. Very nicely, Gupta sir. Actually, really, I am very happy to talk to you. I think you are a very intelligent person. I must appreciate you. I'll come back to you. Some question will be there. I am coming to Shri Sunil Gupta, who is Vice President, Research and Resolution Professional LLP. He has a vast experience under the fields. Mr. Gupta, I want from you, what are the major challenges in managing the stress assets under IBC? There are some challenges under the stress assets. Either you talk about the Prudential framework or you talk about the IBC, and just specifically I am asking you, what are the challenges you feel under the IBC? Mr. Gupta. Sunil Gupta. Mr. Gupta, you are not available?
Sir, thank you very much. I am available. I was on mute. First of all, thank you very much for inviting me to this August gathering where I am having panelists, very, very senior professionals. And coming to the question that you have raised, so the foremost challenge that we feel we are facing is the delay. The delay in resolving an asset. And the delay is basically what we are finding is for various reasons. The major reason is non-cooperation from the corporate debtor, the management, the employees, the auditors, the people, the key management personnel of the corporate debtor, where we are not getting the records, we're not getting information, so that the information can be easily posted and complied. That also lack of information also leads to delay in, or rather I will say challenging the claims that we have received. Because if we can have the information from the corporate debtor, perfect information, then claims can be verified or collated in an easy manner and time-bound manner. So this is the one challenge that particularly we are facing. Second is, one important is that, and when an RP is considered, RP is not a professional who can handle all types of businesses. Now, RP is either a lawyer, or a cost accountant, a chartered accountant, or a company secretary. Now, they are financial, with a financial background, though they have adequate business acumen, but even then, they are not technocrats. They are not some of them maybe, but all of them are not capable of handling very, very typical business solutions, business process situations. For that, they need some guidance or some professionals for that. This is one of the biggest challenges that we are facing, particularly the ongoing or running projects or running units, where we need some professionals like valuers. Similarly, we should have some professionals which are available for running the businesses. Third challenge that major challenge that I feel is on the legal side. The legal acumen of the people, of the claimants, of the creditors. I'm not saying about lenders, but these bankers and FIs, because they are adequately supported by the legal teams. But when we go to the operational creditors, when we go to the home buyers or the allottees, they don't have the legal acumen. They're not aware of how to make a claim, how to settle a claim, how to prepare a document. In this case, and you will find that once they file a claim, from next day onwards, they'll just start saying, sir, when we will get the money. Now, these are the challenge for the IP on operating a stress asset. Stress, already there is a stress. The funds are, again, one we discussed very recently in this itself, the interim finance. Now, when the lenders or the bankers are the COC members, sometimes even they are not very keen to fund the interim finance, which is having a priority of over all the payments, all the recoveries that are being made. Any payment which will be made first will be of CIRP cost, and interim finance forms a part of CIRP cost. But we are finding it very, very difficult, even for the lenders are not providing the interim finance. Particularly in case of the real estate, where a humongous amount has been invested by the allottees, they are not having funds to further fund the CIRP cost, or running the unit, or getting the completing the project. Now, in this case, it becomes very challenging for a resolution professional or its team to run that unit or operate that asset under stress. For this, again, we seek that there should be some guidelines which should come. And in this regard, I would like to share that recently IBBI has issued one discussion paper where they want entire amount to be put in escrow account, and where they can operate, these RP can operate smoothly. Because you see, I'm as an IP, I am appointing a valuer, and there is no fund. No valuer is ready to get appointed because there are no funds. And once they submit a report, they will definitely ask for the money for the services that they have provided. These are certain challenges that we are facing, or generally that we feel under the IBC, where the stress asset has to be managed.
There is one scheme for the pre-pack for the SME sector. It is not picking up very clearly. What do you feel that? Whether this cannot be extended to other units also? What do you feel?
Sir, pre-pack in SME sector is basically, I can say, a practice session of the IBC.
Okay.
We are very, very hopeful that going forward, this pre-pack will be extended. First of all, the pre-pack, why, so it is my opinion, why pre-pack is not picking up is that normally if the account is not an NPA, then banks are not very keen to go for a pre-pack, because again, pre-pack may lead to the account being restructured and reclassification. Banks are not very keen. Number one. Number two, again, coming back to acumen, legal acumen. I can tell you with my experience that a lot of bankers are not even aware of what is pre-pack. They are looking at things still under the Prudential framework of RBI. They are not looking pre-pack as an IBC tool. So this is one thing. But as I told you earlier, sir, we are very, very hopeful, because this is a practice session of MSME. Now we are very hopeful that it will be extended to other entities as well. And maybe in next 1 year, 1.5 years, we will see the light of the day where it is extended. And secondly, we are also hopeful that once this comes to for other applicable to other entities, it will see a better execution and implementation, better, more interest will be seen into the cases, because even the entities are not aware of what is pre-pack.
What is your suggestion? I am asking you suggestion for that PPAC, because for SME sector, it is a very good scheme for that. Like it had not picked up. Whether it cannot be introduced for other sector also.
So that's why I'm saying it is. My suggestion would be it should be implemented, or it should be extended to other sectors, other entities, larger entities.
Okay. Although you feel that it can be extended.
Yeah, it should be, and we are very hopeful that it will be extended, because this was only a practice session, or rather I will say it is a trial that bank step by step action is being taken by the government. They were checking the waters, whether how it is working, what are the challenges which will be faced, so that when the larger entities are coming, the challenges are reduced to that extent and they are captured into the law adequately.
Mr. Gupta, you are having only 15 live cases and 5 you are already completed. What I want one question from you, whether you feel that the operational creditors brought under CIRP, what will be status of the account with the bank? One operational creditor has gone for the NSALT. What will be the status of that account with the banker?
So now, if a operational creditor initiates a CIRP, then what will happen there? If it is a CIRP, then definitely the no payments will be made after the commencement of CIRP, and the account during the CIRP itself after 90 days. For example, if it is standard as on the date of insolvency commencement, then after maybe the next due date is 15 days thereafter, then after 105 days, the account will become an NPA in the banks. Number one. Number two, if it is even if it is resolved, then what will happen that if it is a change in management, then the account can be restored because there is a change in management. Again, the IRAC norms will be applicable as far as banks are concerned, and banks records are concerned. They will be taking as per the IRAC norms of RBI, including the Prudential norms, and they will be upgraded as per the IRAC and Prudential norms as well. In case under NCIRP, when there is a change in management and still there is a continuation of debt, because sometimes the entire debt is not paid upfront, it is paid over a period of time. Sometimes they say it will be paid over a period of 2 years or 3 years. Then in that case, the account will be upgraded once there is a change in management. Otherwise, during the CIRP, the account will be termed as an NPA. Now, if in CIRP also, if there is a possibility where the owners, the existing promoters take over the company, where they are eligible under section 29A, they are not ineligible to bid for that company, and then they took over, then in that case, sir, the account will continue to remain under NPA, and it will be upgraded as per the resolution framework and the IRAC norms.
There is one question from the participant, whether CRP can be initiated against PG. Only if no
Pardon me, sir?
What is writing, whether CIRP can be initiated against PG. Only if no CRP or liquidation is pending against CD, against which the PG is given by the individual company. Have any view in that respect?
Sir, I think a very pertinent question, very, very important for particularly for banks. Sir, first is when there is a insolvency resolution of a personal individuals or personal guarantors, it is called PIRP, Personal Insolvency Resolution Process. And in this case, sir, I would like to share one of the very important case where of Ferroalloys Corporation, versus REC, where NCLAT has held that they are the guarantee and the borrowing are two different and coexistent liabilities, and there is no need that CIRP of the borrower should be initiated before taking up the personal insolvency of the personal guarantors. They are two different schemes, and it is very clearly stated by the NCLAT that the CIRP, rather the personal insolvency, can be initiated even before the CIRP of the borrower is taken any action, even if it is not initiated. For example, I can tell you if I am a personal guarantor, the lender may directly take the action without taking any action or without even contemplating any action against the borrower, because they are coexistent.
Okay. Very nice, Gupta ji. I will come back to you. Any question will be there. So now I'm coming to Shri Rahul Jain. Jain sir. Jain sir, I think from the opening remarks you are right very clearly. Everything you are very clear. This I want to know, because you are a IP in one infrastructure sector also. Have any experience for that infrastructure? How the IP faces any problem or challenge in infrastructure, sir? Mr. Rahul.
Actually, at the very instance, I would like to say that IBC itself is a very challenging field.
Sir.
So
you are a pillar. Pillar of congratulations, sir.
So IBC itself is a very challenging field, and the one great, if you'll ask me, one big thing that we get from IBC, from the success of CIRP, one big thing is the successful resolution applicant gets a clean slate, as mentioned by Honorable Supreme Court in SR Steel case. The successful resolution applicant will get clean slate. All government dues will be categorized as operational creditor. They all will lapse. There will be no CBI or an enforcement directorate proceedings against the corporate debtor post CIRP. So the chances of resolutions becomes very high, because we have seen that in OTS, when the existing promoters go for OTS, they can settle the bank dues, but they still keep on facing these problems. So one thing is this, that I would like to add, that CIRP success increases the chances of revival of the corporate debtor. Second thing is infrastructure is a bit difficult field, because infrastructure can be divided into 2-3 fields further. Like we can talk about the road infrastructure and the general infrastructure, where the corporate debtor need to deal with the government. And we have seen practically that most of the time the problem they face is the liquidity issue, because they have to pay creditor within the credit limit, like 60 days, 90 days. This is the period within which they have to pay to the creditors. But when they have to deal with the government, if they are doing government projects, they are not getting money from the government. Their cases goes to the courts for arbitration and all. Recently, we have seen Reliance Infrastructure case also. They got 6,000 crore rupees from the Supreme Court order that 6,000 rupees to be given to Reliance Infrastructure from Delhi Metro. So these are the issues that infrastructure companies face, because there is unnecessary stress which should not be there. So there is a genuine stress there. In real estate cases, we have seen that there is no option. If construction work is 50, 60, 70% complete, there is no option going for liquidation. If it's a vacant land, then obviously we can go for liquidation. But if the project is in the midway, the home buyers will not get anything, and they want a house. I'm telling you, the only expectation of home buyers is to get a house. This is what they want, and this is from my side.
Thank you very much, Mr. Jain. Then one question is there, because you are expert in the financial reporting, transaction advisory also. This is one question from Mr. Manoj Patil. Can NPA resolutions be considered out of the OTS and director come out through NPA status when whole amount is paid, when their business is growing, having multiple purchase order can be considered in IBC. What kind of cases should be considered through IBC? Have any view for that, Mr. Jain?
Sir, I think this question would be more relevant to a banker side because
No,
to be honest,
I can give a reply. Like let we should ask Mr. PNB DGM.
yes,
Sir,
sir.
you can
Thank
give anything, sir. Mukul,
please repeat your
sir,
question. Yes.
you can say something for that. But
Sir, please, will you please
can also
repeat?
as a banker, if you reply it, otherwise I will reply this question.
Sir, please repeat your question, sir.
This is from Manoj Patel. Can NPA resolution be considered out of OTS? This is the first point. Can NPA's resolution be considered out of OTS? And director come out through NPA status when whole amount is paid. Yeah, it is okay. One whole amount paid, there is no NPA status. Nah? When their business is growing, suppose their business is growing, having multiple purchase order can be considered in IBC.
No, one thing I want to say, we have from banker point of view, we have one tagging facility arrangement. Restructuring is of course there.
Yes.
After restructuring provision is there after means passing through that phase, one account can be upgraded, and of course a lift is there, and mindset of rehabilitation is there. One tagging arrangement sort of thing is also there, where we generally allow the operation in the account, even if account is NPA, with the 10%, 50%, 20% cutback facility, even if account is NPA, and all the recovery actions are kept in abeyance. Main aim is to make the unit as a going concern and just give the opportunity to unit to function normally and clear the overdue which has caused the account to be in NPA status. So these two things are practically, as bankers' point of view, practical point of view, I can say that even if account is in NPA status, this two things we usually do at our level. But for technical things,
point is very clear. When he's coming out of the NPAs, he has paid X amount, business is growing, definitely bank can consider anything. Why you want to go to IBC? There's no point for going to IBC. IBC is insolvency and bankruptcy. When he is bankrupt, when he is not a insolvent, then what he used to go to IBC? I think question is very clear.
Sir, Gupta sir, please sir. One more panelist is there, Mr. C and IP Manoj Kumar Anand. You can ask for some question for him.
I am asking this Surinder Rajan. Surinder Rajan is there. Other question, what we are going to do is Mr. Jain, we will reply to all the questions because time is going to up. Only one question, what is on the screen, we are taking it. So I am requesting Shri Singhvi sir. Singhvi sir, you can reply this question. Has the experience during the last few years in CIRP given any clue or insight about the causes of NPA in medium-sized account? And are the banks able to take prudence in employment at all stages of the credit portfolio management? Have any views around that respect, Mr. Singhvi sir?
Sir, my experience with bankers is now the bankers are more trained. Previously, what was happening? Only HO was trained or higher level officials were aware about IBC, and they were only concentrating on the big value accounts.
Okay, sir.
But over the period of this 6 years, I have seen that the education has toppled to the branch level also. And now they are very, I would say, very alert about if there is some sort of distortion like this. And today they are also asking, in fact, in 1 or 2 banks I have seen, they are at the year end asking whether any operational creditor has filed any insolvency case against the company.
Sure.
So they are now actually alert before IBC is actually triggered, because previously what was happening, only banks were aware about financial creditors or NPAs, but now they're also taking into consideration whether operational creditors are also filing cases or not, because once it gets triggered, everybody gets affected.
I agree with you. Because this operational creditor have a full right. They can also go to LCATL, and even financial creditor are going it. Even the borrowers can also go to the LCATL for resolutions. What is the problem with that? They can also go and settle the score. Because insolvency is there, then he has to prove the insolvency or the bankruptcy. I think there is no issue for that. Regarding this question, sir, what are you feeling in that respect? If the NPA account is there, he can definitely go there. No? There's no problem for that account. This is Sanjay Prakash Sahu. Why a recovery by the financial creditor under IBC to 33% as the data shows? Which I opening remark I told. The why is not a question for that. Lekin major point is about 7.5 trillion. They have filed a claim, out of which 2.50 trillion has been recovered. That is the major aspect. What is the reason for that? Anybody can say, sir, anything? Dr. Sanjay Sahu, Prakash Sahu, is asking, why are the recovery by financial creditor under IBC shrunk? Have any reason for that, sir? Any eminent analyst? Any view for that? Yoji, any view? And Gupta ji, I think you can give a reply for this. Mr. Gupta?
Sir, may I respond to this?
Please.
Sir, the reason is, there are multiple reasons I can tell you. One is people are thinking that the company will be coming to liquidation. Let us wait for that. A lot of times I am finding that people are saying, let us wait for this, the company, let the company come to liquidation. Unless and until there is average interest, people are not buying it. That is one challenge. Second is, the valuation that we are getting at the time of, again, the difference that we were discussing during the time, we have given loans against inventories, against the debtors. Now, this has become very, very challenging. The debtors are either sole proprietorship or partnership firms. In this case, the EPC company or the trading companies, the recovery is practically minimal. There are no assets of the corporate debtor. The assets are leased. There is certain equipment which is lying for the EPC company, for which the lenders are, the equipment finance are having exclusive charge on that, and the other lenders having the charge on the debtors and inventory. The inventory is gone because there is a humongous amount of time from the initiation of or filing first application or filing first claim to admission. Sometimes they have inadequate time to remove all the inventories. The inventory, in most of the cases, we are finding is actually non-existing inventory, or the inventory is very, very poor quality. Either they are rusted iron rods or rusted iron material, or they are in a very, very dilapidated condition, the inventory. The debtors are non-recoverable. The debtors are, as I told you, then mostly are non-corporate debtors, which they know they are not coming under CIRP. So what happens then these debtors say, okay, we are not paying, or the amount is not there, outstanding is not there. Certain cases, they say they have paid, the amount has not been booked. And we have found in certain cases, I can tell you with my experience, the amount has been recovered and it has been posted to certain different account, some dummy account, where the debtors are shown for the purpose of this the DP drawing power, and the banks continue to lend to those creditors, to those borrowers. So these are the reasons for lower recovery. We have to find some ways where due diligence, again, the monitoring word that we initially discussed, monitoring is very, very key to control this low recovery, sir.
Gupta ji, your mic is on mute.
Sir, unmute कर लीजिए अपने आप को.
Sorry for that. So I think that is a point is your inventory has gone because the security has been siphoned off or something like that, or haircut is also there. If you're talking about the big clients, as we discuss SR or Bhushan or other thing, there is quite higher cut are also very important aspect in that respect.
And one more thing, sir, I will just like to share there that where even when the recovery is possible, we are not finding the value of those assets worth selling it.
That's why I'm telling. No, that is a major reason why it is recovery is less. So I am coming to end, Mr. Gupta, because now time is there. So I tried that this session.
Sir.
Please, Gupta ji, please.
I just give you a very good one small example that we had dissolved one company, which we did 3-4 times valuation, and the valuation was not more than 5.5 crore. Okay, the company went to BIFR in 2003-4. Okay, PF department raised the claim till 1997. We settled the account at 54 lakh against the demand of 85 lakh.
Okay.
And what happened? This company we sold at 18. We fetched more than 19 crore rupees. Okay, and we paid everyone, even though we are searching all the shareholders who are nowadays in Europe or USA.
They are in liquidation. That company was in liquidation.
Yeah, liquidation. This company went to BIFR in 2003.
Oh, kya baat hai, kya baat.
And we also deposit 4.5 crore rupees to IBBI in liquidation account.
Oh, आप जैसा IP चाहिए sir, आप जैसा आदमी चाहिए गुप्ता जी जैसा.
Just to understand it.
Bank will very happy for you, sir.
But in that case, no bank was there. Only other financial creditors were there.
Very nice.
The excise department got entire 6 crore rupees.
Our statutory liability, they have also paid.
Everything we paid. Everything we paid.
Oh,
we paid shareholders 8.6 rupees against 10 rupees value.
So at the end, I will request Mr. Manoj Anand to propose a vote of thanks. Before that, I am just telling that this session I tried, it should be a practical section instead of a bookish, because all internet, everything is available in the internet. We want to talk to our panelists to pour our heart and what they are doing it and what is their experience in the different fields. I think this webinar will be very useful for the listener, because home buyer, we are talking about the home buyer, we are talking about the CIRP, we are talking about other aspects also. Some questions we could not reply. So I will try that. The question has been received by me. So we will see that. We should be reply through Mr. Jain, and proper reply should go from our side also. That because timing was not so I cannot take each and every question for that. Lekin I now request Sri Manoj Anand to please propose vote of thanks. I'm just informing you to all the participants that we have more than 500 registration with us, and people are blessing us and giving us. I'm only requesting all the participants to give their feedback, so that feedback will be very useful for us to conduct another webinar. I'm requesting Sri Manoj Anand, sir.
Thank you very much. Thank you very much. Thank you. You know, in fact, on parallel, I was also running one webinar where the issue was COC versus insolvency professional as an RP or IRP, and what are expectations from each other, and we are deliberating on it. In any case, before I start my vote of thanks, I would like to address the all IP community and especially the panelists here. Two things. One is that very soon, insolvency professional entity is going to be recognized as for the work of insolvency professional. Like, I mean to say that IP will be appointed as IRP, RP, or liquidator. One thing. Second thing is that 2 days ago, IBBI issued fee structure, which was a very big demand of IPs. whereas the discussion paper has issued and notification has also issued. Basically, it has been divided in two parts. 1.5 लाख रुपया कम से कम फीस रखी है, 7.5 लाख रुपया मैक्सिमम फीस रखी है, और उसके साथ एक 5 करोड़ रुपए का इंसेंटिव भी दिया है, which is something very good. और
दो इंसेंटिव है उसमें 5 करोड़ की।
हाँ सर, वो दोनों मिला के 5 करोड़ है। तो उसके अंदर दो चीजें हैं। एक ये है कि अगर आप टाइमली खत्म कर दो, तो 3 कैटेगरी में उसके अंदर डिवाइड करा गया, 180 दिन, 330 दिन और उसके बीच के 270 डेज। और दूसरा ये रखा गया है कि अगर आप रियलाइजेशन वैल्यू से ज्यादा रिकवरी कर लो, हाउ पर्टिकुलरली इट विल बी इम्प्लीमेंटेड। बट दिस इज समथिंग वेरी गुड that we in solvency professionals were demanding a lot कि भैया फीस स्ट्रक्चर का कुछ इंडिकेटिव दो। एंड हाँ, उसके साथ एक और चीज कि वो हमारे पैसे मिलने में मेनी टाइम्स दिक्कत होती है, उसके लिए दे आर कमिंग आउट विद द गाइडलाइंस ऑफ एसक्यू अकाउंट आल्सो। So that is also, two just developments of the last 1 or 2 days I thought of sharing with my fellow brothers. This is all. I'm really, I entered quite late. Maybe I missed this webinar, but I shall definitely see the recording later on. I'm really thankful to Mr. Mukul Sahai, DGM PNB. Sir, नजर नहीं आ रहे मेरे को फोटो। हाँ सर, आ रहे हैं, आपकी फोटो नहीं आ रही, नाम आपका आ रहा है। CAIP राहुल जैन जी, Advocate CA Nupun Singhal ji. Nupun ji, thank you very much. You always enlightened in every webinar, and I'm really now a good fan of yours. CMA Ashok Kumar Gupta ji, IP also. Mr. Sunil Gupta, Vice President, and anything can't happen without organizers. तो ऑर्गेनाइजर में अगर सबसे पहला नाम आता है तो वो आता है प्रवीण जैन जी का। प्रवीण जी, थैंक यू वेरी मच for organizing so frequently with so many pain. I know कि अगर एक वेबिनार करना होता है तो उसके पीछे कितनी एफर्ट्स पड़ती हैं, and making all the panelists and all the audience to get collected. Advocate Piyush Jain ji, CIP Ritu Rastogi ji, IP RK Goyal ji, and coordinator CA Palvi ji, and Mr. MK Gupta ji, director. So with this vote of thanks, Praveen ji, I request you to end the meeting. Thank you very much.
Sir, special thanks to Mr. KK Gupta ji, so that webinar can be held on this account only. So thanks of all of panelists, guest of honors, and moderator, coordinator, and participants. Thanks a lot. Thanks a lot.
Thank you.
Thank you.
Thank you.
Mr. Jain, you are the
Thank you very much. Thank you.
I must say you are architect of that. With your blessing, I think this can be happened. And I think more than 500 registration we have got it. I really achievable, commendable for that. Thank you very much.
Thank you, sir. Thank you. Thank you. Thanks a lot, sir.
Thank you.
Thank you very much. Thank you. Bye bye.